Hello, this is Michael Mayoral from Perez Mayoral, PA, and we're here to bring you the common tricks HOAs use to avoid paying for water damage. We represent homeowners across the state of Florida living in condo associations and homes governed by HOAs, and one of the most common disputes we handle are property damage disputes where someone's home has been damaged due to a leaking roof, leaking walls, leaking windows, burst pipe, and all things of that sort. What we have noticed in Florida in our practice is very common and unscrupulous things that HOAs and condo associations do to try to get out of these claims, to try to get out of liability, and to try to get out of paying for damage that they caused. The first thing we typically see, I like to call deny. And this is a straight up denial where the association will pretty much deny that anything's happening. They'll say, leak? What leak? We have no evidence of a leak. That's why it's really important that if you're experiencing a leak, if you're experiencing water entering your unit, take out your phone, videotape it, take photos, document it, so they can't later deny that this happened at all. The second thing we see, once an association actually gets out there and notices there's a leak, they will attempt to shift blame. They'll do two things, either to try to blame another unit, to say that water must be coming from your upstairs neighbor, or they'll try to blame the unit owner themselves to say, well, that water's coming from one of your appliances or one of your drains or something like that, many times without actual evidence of that. So we see a shifting of the blame onto other parties. The next thing we see, if an association has agreed that they caused a leak, that it was a roof or a pipe or something that is a common element, what we see is minimum repairs, almost like bargaining. An association will say, essentially, yes, we caused a leak. Yes, it was our roof that we haven't replaced for 30 years. Yes, it was our pipes that we haven't maintained. But we will agree to repair the roof and we'll repair some of the drywall. We'll repair the drywall. You have to repair the rest. They will agree to do just minimum repairs. They will do bargaining, even though it is completely their responsibility, even though the association usually is completely on the hook for cost of repairs to the inside of the unit, to the interior finishes, for lost rent, alternative living expenses, consequential damages. They will not inform unit owners of this. They will bargain and try to do the least repairs possible. The next thing we see in this dispute is what's called gaslighting. Essentially, what associations will do is point to the governing documents and make an intellectually dishonest argument, arguing that they're not at fault. What they will do is point out the declaration, the bylaws of the association that say that unit owners are responsible for maintaining their units. And they'll go to a unit owner who the association has wrecked their unit, has destroyed it, and they'll pull out the declaration and say, don't you see this? This says that you have to maintain your unit and we have to maintain the roof. Therefore, we'll fix the roof and you'll fix your unit. This is completely dishonest. That is not how the law works. That's not how the law has worked for the past 2,000 years. People are responsible for damages when they violate the law. People are responsible for damages when they breach contracts. And when an association fails to maintain a roof and it destroys a unit and leaks into it, they have breached the declaration, they have breached a contract, and they, just like everyone else, are responsible for the consequential damages. This is identical to the situation of car accidents. I normally maintain my car and I normally have insurance on my car, but if someone rear ends me, they are now at fault. They are liable. And even though I normally maintain my car and I normally insure it, I can collect from the at fault party. It's the same exact thing in the condominium or HOA context. While yes, you have to typically maintain your unit, while yes, you typically even have to have an insurance policy to cover damage for your home, if an at-fault party damages it, you can sue them. You could go after them. And ladies and gentlemen, this is what my firm does. We handle these cases across the state of Florida. We offer free consultations on them. Most of them we are able to take on a contingency basis and really seek justice for people facing these situations. The last thing we see associations do in these disputes before they get to us is really just disappear. Once the person has pled with them, try to tell them, what do you mean? You're obviously responsible for this. I'm going to seek a lawyer. I'm going to sue you guys if you don't do these repairs. They will just disappear to try to call the person's bluff. The problem is There are not a lot of attorneys who do what I do. There's not a lot of law firms who do what we do here at Perez Mayoral, PA, where we sue condo associations and HOAs. It's a complicated area of the law. There are even fewer attorneys who take property damage cases like these on a contingency basis. So many HOAs and condo associations are trying to see if that person is indeed going to hire an attorney, if that person is indeed going to be able to afford that attorney. So they pretty much wait and see if they're going to get sued, which is not the proper way to do business, especially with people who are paying you monthly dues for maintenance. And that's where we typically come in these situations. People call us exacerbated, really grinded down by the whole situation of trying to plead with their association to do the right thing. And we are really, really proud of our practice group of what we do with these cases. Like I said before, we handle these cases throughout Florida. If an association is denying repairs and they're doing this process of deny, delay, gaslight, we really have a team dedicated to seeking justice in these cases and getting clients the full cost of repairs, full out-of-pocket expenses, alternative living expenses, lost rent, and everything that is needed to bring back these people, these unit owners, back to the place they were before the association's failure to maintain the building damaged their unit, damaged their property, and many times damages their health with a lot of the conditions of mold and the sort. If you or someone you know is facing a property damage dispute under a condo association or HOA, do not hesitate to call my law firm to put them in contact with us. Again, these cases, we provide free consultations on cases involving property damage to units, and we many times are able to take these cases on a contingency basis to provide homeowners with the leverage they otherwise wouldn't have in getting justice in these cases.